Just before you resume, Mr. Coppell, the Court's had a request from, well, two requests, one from the Press Association and one from the Incorporated Council of Law Reporting for copies of the skeleton argument. And we can't see there's any problem. I thought I'd just raise it with the parties.
We've action on
Right. Thank you. Yes.
Just one point of fact from the proceedings this morning. UKIP is and was at the material time a limited company.
Oh, right. Yeah.
So I was about to show you what the Upper Tribunal had said about the aim of Section 24. It's paragraph 150 of the Upper Tribunal's decision on page 109 of the core bundle. And having considered the aspects of the first tier tribunal's decision, which I attempted to take you to, and Sir James did take you to, paragraph 109. The tribunal concludes that the FTT was in error in its description of the aim of the legislation. Whilst the legislation does indeed promote private funding of political parties, it's not correct to describe the conditions as being intended to prevent abuse of the relief by restricting donations to parties that play a meaningful role within national political debate. The aim is much more specific. It is to provide tax relief on donations to political parties that are participating in parliamentary democracy by being represented in the House of Commons and not in respect of individual independent MPs. It's a bit of a mouthful, but it's more or less a description of what Section 24 does, as I've submitted. One also finds in other parts of the Upper Tribunal's judgment perhaps an even more detailed expression of the aim. Paragraph 182, subparagraph 3 on page 116. The bundle, subparagraph 3, the Upper Tribunal says, as already explained, the aim of Section 24 is to provide tax relief on donations to recognisable political parties that are participating in parliamentary democracy by being represented in the House of Commons following a general election, rather than to confer relief on political donations generally. Slightly differently put, but again a description of what Section 24 does. Now, going back to 150, we say that the Upper Tribunal should not have concluded that the first tier tribunal was in error. It was not an error of law, even if the Upper Tribunal might have wished to characterise the aim more narrowly, or in more specific terms, than did the first tier tribunal. In any event, the first tier tribunal was correct and had reflected what the respondents had submitted to it at that stage was the aim of the legislation. And the Upper Tribunal's alternative aim, for the reasons I gave before lunch, we submit was incorrect and was an account of the effect of Section 24, which prejudged the application of the remainder of the proportionality test. Now, I've been making submissions up to now as to what was the aim of Section 24. Now, that may not be the right question to ask. If you agree with my ground one, so that this is a case of direct discrimination, then the relevant question is not what was the aim of section 24. It is what was or what is the aim of the difference of treatment on grounds of political opinion, which you will have decided is a consequence of section 24. So it's the aim of the difference of treatment. And we've explained the basis for that in paragraph 35 of our skeleton argument, with a quote from, or a reference to A.L. Serbia in the Supreme Court. And I'm going to show you an actual reference in a moment to contrast direct discrimination, where the justification must be of the difference of treatment, the discriminatory effect, and indirect discrimination, where the justification must be directed at the provision as a whole, and therefore the aim in question is of the provision as a whole. And that distinction is clearly drawn by Baroness Hale in, I believe, uncontroversial terms in the SG case, Bundle 2, tab 35. Benefits cap case in the Supreme Court. Baroness Hale was in the minority, but the point I'm taking you to is, as I say, I believe uncontroversial. It's page 1093. It's 1092, paragraph 188. How is the discrimination justified? And she sets out principles from Steck in the United Kingdom, from Strasbourg, and says 2 points are clear from this. The first is that it is not the scheme as a whole which has to be justified, but its discriminatory effect. CA against Secretary and AL Serbia. It's not enough for the government to explain why they brought in a benefit cap scheme. That can readily be understood. They have to explain why they brought in the scheme in a way which has disproportionately adverse effects on women. At 189, however, it is important to understand that what is needed to justify indirect is from what is needed to justify direct discrimination. In direct discrimination, it's necessary to justify treating women differently from men. In indirect discrimination, by definition, women and men are treated in the same way. The measure in question is neutral on its face. It's not necessarily targeted at women or intended to treat them less favourably than men. Men also suffer from it, but women are disproportionately affected, either because there are many more of them affected by it than men, or because they'll find it harder to comply with it. It is therefore the measure itself which has to be justified, rather than the fact that women are disproportionately affected by it. So, direct discrimination, what is the aim of the difference of treatment? That's what you're justifying. Indirect discrimination, what is the aim of the measure as a whole? Because that's what you're justifying. And Article 10, if we're in Article 10 or 11 territory, it's what is the justification for the interference with Mr. Banks's rights, for the which really again looks at the measure as a whole. But if you are with me on ground one, so this is direct discrimination on grounds of political opinion, then the relevant aim is the aim of distinguishing between some political parties and other political parties. Some donors and other donors based on their political opinion.
Was that right? why isn't the aim to ensure that only those donations which are to political parties currently participating in parliamentary democracy, or however it's put by the Upper Tribunal?
Well, the Upper Tribunal proceeded on the basis that, if anything, this was indirect discrimination. So all of its discussion is
yeah, understood. But I mean, I'm just trying to follow.
Yes.
What difference it makes.
Well, if we're focusing on the difference of treatment and the aim, what's the aim, the objective for distinguishing between some political parties and other political parties? The aim of that is not to channel private funds to political parties. The aim of that must be, we would submit, the preventing abuse limb of the first tier tribunal's identification of the aim. But it is a different question from what is the justification for the measure as a whole. Both the first tier tribunal and the upper tribunal looked at the aim of the measure as a whole because they proceeded on the basis of indirect discrimination. But if it's direct, then it's different, and we submit that one can take from the first tier tribunal's findings that the aim of the distinction is prevention of abuse.
Yeah.
Now,
if you're right about that, you say if the aim is the aim of preventing abuse, as described, then that could have been achieved by a much less intrusive measure.
yes.
You'd reach the same end if the conditions were related to the last general election, the next general election, by-elections, defections, European elections, etc., etc.
Yes, these would all be serious political parties, established political parties, presence on the national stage, etc. One can understand, though, that see the Neil report, that simply applying the exemption to any registered political party might not be enough to prevent abuse, because anybody can register a party.
Well, there are plenty of political parties that are registered. You can see my.
So, yes. So if your concern is to prevent abuse, keep the exemption within reasonable bounds, it's much too restrictive in the way that it's been framed. So the other stages of the justification test, then we've got legitimate aim. That's the first stage, and any of these aims that we've been discussing obviously are legitimate aims. I'm not speaking of that. One then has to consider whether the aim justifies the means in broad terms, and we say that Section 24 unjustifiably prejudices political parties who participate in parliamentary democracy, who enjoy a substantial measure of public support, but do not have MPs elected at general elections on the electoral system that we currently have. Other criticisms can be made, and I'll come on to make them, but I start again with the first tier tribunal's analysis of proportionality, because we say, again, essentially the first tier tribunal's analysis was correct, and there wasn't a sufficient reason for the upper tribunal to interfere with it. And the first tier tribunal's analysis is quite concisely state it. There's a long run to it, but in paragraph 115 on page 192. The judge says, I've accepted it's legitimate to place some restrictions on tax relief or donations to political parties in order to prevent abuse. Tax relief is, after all, a form of public funding for political parties. A balance has to be struck between achieving that legitimate aim and the impact on Mr. Banks's rights not to be discriminated against on grounds of opinion. I've also accepted it's not irrational for those limits to be based on electoral success and or public support. There are, of course, many ways in which it would be possible for a political party to demonstrate a level of electoral success or political support. Let me give some examples of that. The choice that Parliament has made focuses to a significant extent, although not exclusively, on past success in elections to the House of Commons. That not exclusively is the 150,000 votes if you only have one MP. I must give due deference to that legislative choice, which I do. The difficulty is that those elections take place on a first-past-the-post system, which, as Mr. Banks' case illustrates, is not on its own a reliable barometer of public support. The resulting test is liable to be prejudicial to supporters of new and as yet unrepresented parties, even where those parties can demonstrate meaningful levels of public support. Cannot agree that the current test is an appropriate one to apply to tax relief or donations. There are a number of other options available which would not have such a disproportionate effect on supporters of new parties or parties that, despite being able to demonstrate a meaningful level of public support, are not represented in a Parliament elected under first-past-the-post system. Now, we say that was a fair, sensible and legitimate conclusion for the First Tier Tribunal to reach. You'll be well aware of the restrictions on the role of an appellate court in overturning a proportionality analysis, particularly where an appeal is on point of law only. The Upper Tribunal justified its interfering and redoing the Tribunal's proportionality analysis on the basis that the Tribunal had got the aim wrong. 136 of the Upper Tribunal at 105 for the reasons explained below, we have concluded the First Tier Tribunal was in error in its description of the aim of the legislation at 109, and this error also affected the FTT's assessment of proportionality, and slightly expanded upon in 178 on page 115, where the FTT's error in identifying the aim of the legislation affected its assessment of proportionality. This is evident, for example, from the reference to abuse in 115.1 of the decision. This was an error of law, and for that reason we addressed the question of proportionality on the facts of this case. And we say the First Tier Tribunal was not in error in referring to the prevention of abuse as at least part of the aim in question, not least because that was the submission which had been made to it by the respondents, and that was what the Neil report supported. So the Upper Tribunal should not have interfered, we say. So far as your consideration of proportionality is concerned, and assuming that you will will consider the matter for yourselves, even if you ultimately decide not to interfere with one or other of the analyses of the lower tribunals. We submit that there are 5 factors of particular significance to the remainder of the proportionality analysis. The first factor that we rely on is the subject matter of this difference of treatment. And the subject matter is political opinion, freedom of expression, freedom to express your support for a political party by donating to it. This is plainly, we say, a subject matter where the court should be concerned to give very careful consideration to the justification which is advanced. Now, one ought not to need authority for that, but there is authority under Article 14, both that the grounds for the discrimination affects the intensity of the review of the court, and also that political opinion is a suspect ground which ought to give rise to a higher intensity of review, a closer look, as it were, at the justification. The authority for the general proposition that the grounds for discrimination are important is SC, Bundle 2, tab 44. Page 1556. We start on 155, paragraph 90, on intensity of review. Lord Justice Leggett, as he then joins on a judgment by Lady Justice Davies agreed with. Lord Justice Leggett, at the end of paragraph 90, having said that the intensity of the court's review varies according to the context, sets out 3 factors. Then the first factor, 91, as already mentioned, the nature of the ground on which the difference in treatment is based is significant. Thus, in the case law of the European Court, differences in treatment based on race, nationality, gender, religion, sexual orientation, and certain other grounds require particularly convincing and weighty reasons to justify them. And then just below letter B, in other words, the nature of the ground on which the difference in treatment is based will affect the intensity with which the court will scrutinise the profit justification, and hence the readiness with which the court will conclude that there was, in that context, manifestly no reasonable foundation for the difference in treatment. I'll come back to the manifestly without reasonable foundation test, but as a general principle, the grounds of discrimination matter to the intensity of view. And then one has to pick up Bundle 1, tab 17, please, which is the Carson case in the Lords. A case about differential state pension entitlements as between pensioners who've moved abroad to different countries. Paragraph 15 on page 388. Lord Hoffman says, Article 14 expresses the enlightenment value that every human being is entitled to equal respect and to be treated as an end and not a means characteristics such as race, caste, noble birth, membership of a political party, and here a change in value since the Enlightenment, gender, are seldom if ever acceptable grounds for differences in treatment. And then he goes on to explain there are other grounds which are not so suspect, including place of residence and age, which were the two grounds at issue in Carson. And then same bundle, tab 25, case of RJM in the House of Lords, page 694, in the judgment of Lord Walker, and this is his well-known analysis that personal characteristics, now as we've seen, identifiable characteristics, are more like a series of concentric circles. The most personal characteristics are those which are innate, largely immutable, and closely connected with an individual's personality, gender, sexual orientation, pigmentation of skin, hair and eyes, congenital disabilities. Nationality, language, religion and politics may be also innate, depending on a person's family circumstances at birth, or may be acquired, though some religions don't countenance either apostates or converts, but all are regarded as important to the development of an individual's personality. Reflect, it might be said, important values protected by Articles 8 and 10 of the French. So we say that political opinion is one of those suspect grounds which requires a more cogent justification and requires a higher intensity of review by the court. That's my first factor. My second factor is the manner of introduction of section 24 onto statute book and the absence of consideration at that stage of the matters which now arise when section 24 is subjected to Human Rights Act scrutiny. Now that is again a factor going to intensity of review which was set out by Lord Justice Leggett in SC. So we need to go back, I'm afraid, to bundle 2, tab 4. Paragraph 92. A second relevant consideration is whether the measure resulting in differential treatment has been approved by Parliament, and if so, with what degree of scrutiny. And he cites Bank Mellat, and then JS, with the SG as I referred to it before, the benefits cap case, Lord Reed, noting that although the benefits cap scheme, which was the subject of challenge in that case, was not contained in the bill debated in Parliament but in regulations, nevertheless, government proposals had been made clear they were challenged by means of proposed amendments to the bill, and they were the subject of full and intense democratic debate. That is an important consideration. And he goes on, the weight which should be attached to the democratic basis of the decision is even greater where the measure in question has not merely been considered and approved by Parliament, but has been enacted by Parliament in primary legislation. So, primary legislation, that's important, but the extent to which the degree of scrutiny which was applied to the relevant provision is significant, and that is built upon in paragraph 93. A third important factor is whether or to what extent the values and interests relevant to the assessment of proportionality were actually considered when the policy choice was made. So thus it's clear where a public authority has addressed the particular issue before the court and has taken account of the relevant human rights considerations in making its decision, a court will be slow at the balance which was struck. Conversely, where there is no indication this has been done, the court scrutiny is bound to be closer. And the court may have no alternative but to strike the balance for itself, giving due weight to such judgments as were made by the primary decision maker on matters he or it did consider. Now, Lord Justice Leggett had set out at some length earlier in his judgment the parliamentary consideration which was given to the particular provisions that the C case was concerned with, and he returned to consider them at paragraph 155 on page 154. Where at the beginning of 155, at the beginning of his conclusion on justification, I've examined the extent to which relevant values and interests, in particular the interests of the children who will be affected by the two-child limit, were considered by the government and by Parliament. Because as noted earlier, where a public authority has addressed the particular issue before the court and has taken account of the relevant human rights considerations in making its decision, the court will be slower to upset the balance which was struck. The fact that the government did not confront the detriment that would be caused to the interests of the children affected by the two-child limit mandates greater scrutiny than would otherwise be appropriate. On the other hand, it's important to keep in mind that what must be justified for the purpose of the discrimination claim is not the decision to reduce amounts, is the decision to treat families differently and making expenditure cuts on the ground of number of children. That's not a sensitive characteristic or suspect ground, but a status of a peripheral. So it is material to intensity of review to consider, the court to consider to what extent the relevant issues which arise on a proportionality test were confronted by the decision maker at the time that the measure was introduced. Now, as I've submitted, we don't have what one might usually have when considering the proportionality of legislation. One doesn't have the green paper, the white paper, the consultation responses, the impact assessment, the explanatory notes, the whole series of pre-legislative material, or indeed the explanation given by the Minister in Parliament or parliamentary debate on the issue, save for the debate policy, which it's fair to say in my submission doesn't confront any of the issues that we say are of concern under section 24, largely because it was 50 years ago and we didn't have Scottish Parliament, we didn't have an elected European Parliament, etc. So you must, of course, give some weight to the fact that we are concerned with primary legislation, but on the other hand,
all we know then is that the in committee at least the proposed amendment was defeated by a narrow majority, I think. And at some point thereafter, when the legislation actually came forward, it had included a provision which the government had previously been against. And it's no more and no less than that, is it?
It's no more and no less than that, but an absence of consideration is good enough for me on Lord Justice Leggett's analysis, because that is what triggers the more intense review of the court. If there were consideration pre-legislative or in Parliament, that would be different. Third factor, I perhaps have trespassed on that already. The third factor, which is of significance, we say, to this court's proportionality consideration, is the passage of time since 1975, when this provision was introduced. Section 24 was introduced into a political and party system which seems in many respects like ancient history. Our political system has fundamentally changed since then. We have set out some of the relevant matters in paragraph 48 of our skeleton argument, and it's matters like the range of elections in which political parties participate, expanded significantly beyond general elections, direct elections to the European Parliament, relevant at the time of the donations, obviously not relevant now, to devolve legislatures in Wales, Scotland and Northern Ireland, and a system of registration of political parties. All of which led to the statement, in the paragraph of the government's autumn statement that I showed you at the outset of my submissions, opining that there was unfair and inconsistent treatment in the modern context. Whatever the position, the party system back in 1975, in the modern context, Section 24 is anachronistic. And there has been no consideration of Section 24 by Parliament in the meantime. Now, in one sense, it's perhaps unsurprising that a governing political party hasn't been clamouring for reform of a provision from which it benefits necessarily, and smaller parties don't. The reasons matter not. But there has been no parliamentary consideration of this provision since 1975, although a number of reviews and recommendations made about political party funding in the interim, the Neil report, the Hayden Phillips review that we also have in the bundle, but nothing done as yet to reform. So passage of time. The fourth factor, we say, is that the election of MPs to Westminster in a general election is an outdated and inappropriate basis for distinguishing between parties who are deserving of support via the tax system and those who are not. And this is just a straightforward question of reasonableness. Is this a sensible line to draw? We say it is not a measure of seriousness or legitimacy of a party, whether they have succeeded in 2 MPs or 1 MP at a general election, nor is it a measure of the extent of public support for the party.
Well, that's the point that Judge Greenbank made in his judgment at first instance, isn't it? The point about first past the post is skewed in a particular way and doesn't actually tell you anything necessarily about how much support the party has.
Yes. Yes, so UKIP in 2010, 900,000 odd votes, no MPs. 2015, 3 million odd votes, 1 MP. That's the system. But if you're, and we aren't complaining about the system. Let me make that clear. What we do say though is that the number of MPs elected in a general election, given the system, is not a reasonable measure of public support or a reasonable barometer of participation in the political system.
I'm not sure I see the logic of that. I mean, if you were attacking the first past the post system, then I quite take your point. But if you're accepting that, as you would do, and I think one has to in this context, then surely it is a legitimate test to ask whether any MPs have been elected to the Westminster Parliament or not. And if you do decide to have a test of that nature, then obviously you've got to pick a number, and 2 or 1 with a sort of nod in the direction of the popular vote at the same time is surely a defensible way of dealing with it.
Well, I suppose one has to go back to what's a sensible way of dealing with what. What's the objective here?
Yes.
The objective is to prevent abuse, to keep the scope of the exemption within bounds. We don't challenge the system, but it's a quite different question whether the first past the post electoral system should be adopted as a measure of something completely different, or adopted as a yardstick for preventing abuse of the tax system, or even of whether is first past the post a yardstick of whether a party is playing a meaningful role in national debate. First tier tribunal language, no, it's not. You can have millions of votes. You can have scores of elected representatives around the country, and no MP is elected under first past the post. Is the first past the post system even a sensible yardstick for whether parties are participating in parliamentary democracy, which was the language of the Upper Tribunal? Answer again, we say not. You participate in parliamentary democracy by seeking election, putting up candidates, campaigning for Parliament. Whether you happen to have MPs elected under whatever electoral system we have is not doesn't mean you're not participating in parliamentary democracy.
I mean, these are very sensitive areas for a court to get involved in. Well, that was a point that the Upper Tribunal was obviously very influenced by, and in its approach was really that in a very sensitive political area like this, there's a danger of the courts overstepping their proper role if they begin, as it were, pontificating about what's the appropriate nature of the test to be applied.
Yes, well, clearly that was of concern to the Upper Tribunal, and we would submit the Upper Tribunal rather abdicated its duties to evaluate the cogency of the justification. All of the surrounding context, the grounds of discrimination, the lack of parliamentary consideration, the passage of time, all of these factors tend against the cogency of the justification. I've got another one to come as well. But what the Upper Tribunal said in substance was this is all quite sensitive. We'll just leave it to Parliament. But this is freedom of expression. This is discrimination on grounds of political opinion. And this court, as appreciated, we say, of examining in a searching way the force of the justification advanced. So parliamentary democracy, you can stand for election, you can get elected to other parliaments. not necessarily, we say, Westminster MPs to Westminster only. The fifth and final factor that we particularly rely on is that even if election of MPs to Parliament under the first past the post system were an appropriate basis for distinguishing between donations which are exempt and those which are not, there is no rational basis for excluding parties who have MPs as a result of by-elections or defections. We're particularly concerned with by-elections in this case, as I mentioned. UKIP, following the Clacton by-election, following the Rochester by-election, was participating in day-to-day Westminster business in exactly the same way as parties who had MPs elected at the 2010 general election. And I searched for, but with respect, simply could not see in my learned friend's arguments a sensible explanation for why MPs elected through a by-election should not qualify. Whether your yardstick is playing a meaningful role in national debate, whether it's participating in parliamentary democracy, whether it's preventing abuse, however you want to put it, what is wrong, what is different about MPs being elected in a by-election? By-elections.
Well, I mean, this is obviously very speculative, and this may be a very good reason for not going anywhere near a question of this kind. The answer could be that by-elections do tend to throw up rather unusual results because they're often taken as a kind of protest against the government at the time, rather than a more long-term view of how one wants the party in question to be represented at a general election. I mean, we're all used to by-elections, which throw up very heavy swings one way or the other, in a way which is very seldom replicated at general elections. I mean, that's a purely political point of a kind which one would be very reluctant to get drawn into as a court, or at least I would have thought one would, especially without any evidence other than just what one happens to know from reading the newspapers.
Well, one doesn't, of course, have to focus simply on by-elections. I mean, the position was that UKIP had received many hundreds of thousands of votes at the general election, way over the 150,000 threshold. It then acquired one MP and then another MP. But on the basis of this provision from 50 years ago, which didn't grapple at the time with the question of by-elections or any of these other issues, which has never been reconsidered in circumstances where the fiscal system has changed fundamentally. This is, and one appreciates that primary legislation isn't very often held to be incompatible with convention rights, but of all the candidates, political expression, discrimination on grounds of political opinion, all the factors I've just relied upon, this we say is an obvious candidate for incompatibility. I have, I think, two further topics. One is to go back to intensity of review and the manifestly without reasonable foundation test, which is what my learned friends say the court ought to be asking itself. And then I need to deal with Section 3 Human Rights Act interpretation. On manifestly without reasonable foundation, my learned friend's argue that at each stage of the proportionality test, the relevant question for the court is whether whether the justification advanced is manifestly without reasonable foundation or not. There's been a lot of recent case law of the higher courts, of this court and of the Supreme Court, seeking to analyse when does that test apply and when does a different test apply. More or less the latest, certainly outside of the welfare benefits context, and we're not a welfare benefits case, the latest case of this court on which my learned friends rely is the JCWI case in Bundle 3, tab 54. Case is about the so-called right to rent scheme, a measure of, as my lord recall, a measure of immigration control, imposing restrictions on the renting of accommodations of foreign nationals. Yes, at page 2042 from paragraph 125, one sees a debate between Sir James at letter D. A measure such as this aimed at preventing illegal immigration concerns economic and social matters which are preeminently for national authorities, such that the assessment of Parliament that its adverse effects are proportionate to the benefit of the public should be accepted unless manifested without reasonable foundation. And then there's Kaufman at 126, submitting that that test has only ever been applied and only applies in the field of welfare benefits. This isn't a welfare benefits case, and so the manifested without reasonable foundation test doesn't apply. The simple balancing test applies. And then I can skip a few pages to 132 to what Lord Justice Hickenbottom accepted of Mr. Kaufman's submissions. The first was noting the JD case in Strasbourg, where Strasbourg Court limited the application of the manifesto without reasonable foundation test, even in a welfare benefits case, to circumstances where an alleged difference in treatment resulted from a transitional measure forming part of the scheme to correct inequality. We will not refer to any case in our domestic law where the criterion of manifesto without reasonable foundation has been considered, let alone applied, in the context of the consideration of a legislative or executive measure other than in the field of welfare benefits. In Roman 3, in the JS or SG case, Lord Reed added controversial issues of social and economic policy with major implications for public expenditure. Wilson in DA, the test applied in relation to the government's need to justify the discriminatory effect of a rule governing entitlement to welfare benefits. However, insofar as JD differs from the Supreme Court cases to which I referred, we're bound by the latter. Manifest without reasonable foundation test rise from James and the UK non-welfare benefits case. None of the domestic cases expressly states that the application of the manifestly without reasonable foundation criterion only applies in the context of welfare benefits. It does not apply generally to a measure implementing economic or social policy. And Roman 4 over the page, welfare benefits, of course, comprise an area of policy in which both economic and social considerations feature very large. However, there is no apparent logical rationale for restricting the socio-economic policy areas in which Parliament and the Executive, as democratically responsible bodies, are uniquely qualified to assess the public interest as against other interests to those of welfare benefits. There are other sensitive areas, such as social housing and immigration, in which it may equally be said that they are the most appropriate assessors of what is in the public interest and whether the adverse impacts of any proposed or actual measure are proportionate to the benefits in the public interest. And so the point, the conclusion is that if Lord Justice Hickenbottom were required to determine the matter, he would say that the manifestly without reasonable foundation criterion applies to the issue of justification in this case because the right to rent scheme involved a substantial element of economic or social policy, and he then refers to the Drexler case, which is welfare benefits in the local authority context, where the test was also.
Well, that's very clear authority, isn't it? Judgment of Lord Justice Singh to the effect that manifestly without reasonable foundation is not limited to welfare benefit cases, but it extends to all cases involving considerations of social or economic policy.
Well, more or less, my lord. I just need paragraph 140 of Lord Justice Hickenbottom, where he says that the criterion, the manifestly without reasonable foundation criterion, cannot simply apply to some cases where there's an issue of justification in respect of a measure involving an element of social or economic policy separated from other cases by a bright line. No such line can sensibly be drawn. The degree of social and economic policy involved in any measure will be infinitely variable. In my view, the criterion simply recognises that where there's a substantial degree of economic and or social policy involved in a measure, the degree of deference to the assessment of the democratically elected or accountable body that enacts the measure must be accorded great weight because of the wide margin of judgment. And then I think that this is really the point. The greater the element of economic and or social policy involved, the greater the margin of judgment and the greater the deference that should be afforded. So it's not simply any case which has an element of economic or social policy, one must apply a manifestly without reasonable foundation test. Where there is a substantial economic or social policy, yes, that test will be appropriate. But generally, the position is the greater the degree of economic or social policy, the greater the degree of deference should be afforded.
Would you accept that taxation is really by its very nature an area which attracts a similar analysis? I mean, it's you couldn't have a clearer conflict, so to speak, between the wish of the taxpayer not to be partied from his or her resources on the one hand, and the interests of the wider state on the other, as reflected in taxation, which is an inherently sensitive subject which touches on many constitutional rights and matters of importance. And for that reason, surely it's very much in the sphere where Parliament should be left to make the decisions.
So as a general proposition, yes, I do accept that tax is is considered to be an instrument of economic policy and will usually attract a substantial measure of deference. But we are concerned with a particular provision which raises rather particular considerations. Firstly, because it discriminates on a suspect ground, on grounds of political opinion. That is very important. This is not run-of-the-mill tax law. This is suspect grounds discrimination. The second point that I would make is this is not, as many tax measures will be, this is not properly to be regarded as an instrument of economic policy. This particular measure is an instrument for encouraging, for supporting political parties.
Well, yes, but the underlying measure of economic and social policy is the inheritance tax itself, which means that a substantial lifetime gift, at least as the law then stood, and indeed still does, unless it's potentially exempt, is to impose a charge to tax.
Where to draw the line?
Where to draw? Yes, sorry.
Well, sorry, I'm interrupting you.
No,
where to draw the line is quintessentially a matter for
well,
Parliament and government, isn't it?
but where the line is drawn within the inheritance tax universe, as it were, is an instrument, or is a reflection of a desire to support political parties, to encourage the flow of private funds to political parties. This is not a revenue-raising measure. This is not a, as I said a moment ago, an instrument of economic policy. This is supporting political parties as an alternative, effectively, to state funding. So yes, lines have to be drawn, but there is a real danger in my submission of then moving from that proposition to the proposition that it must be a matter for Parliament because it's very sensitive. Parliament didn't consider the issues which arise in our case, and I've made all my submissions about that. The world has fundamentally changed without any reconsideration having been given. So this is a case where the respondents cannot say there's a judgment has been made by Parliament which is a valid judgment and must be respected.
But is that the right question, Mr. Coppell? Isn't the right question whether, insofar as you may very well be right that the judgment hasn't been made because it's 46 years or whatever it is, and nothing's been done since. But isn't at least one question whether, if there is to be a judgment made, if there is to be a judgment made, it's a judgment that should be made not by the court but by Parliament because of the nature of the legislation in question, which is, on any view, involves economic policy in a sense, but also probably involves social policy, doesn't it?
Well, I would say it doesn't involve either economic or social policy. It's a political measure. It's a measure to support political parties, to enhance democracy, parliamentary democracy, whatever you might.
It might be said on that basis is even more a matter for Parliament than it is for us.
It is certainly the case that taxation measures can be used in all sorts of contexts as a form of carrot, as a sort of economic incentive to engage in certain forms of conduct, such as saving for one's retirement and so forth. So from that point of view, I take your point that the section can be seen as intended to encourage giving at least to certain categories of political party. And that's obviously seen as a socially desirable end, which deserves fiscal recognition and indeed fiscal exemption as well. But the nature of the judgments involved are surely still very they still very much fall into the sensitive category, where, on the whole, the courts should not tread, it seems to me.
Well, so just in further response to my the Chancellor, first of all, the court has a duty, see Wilson, what was then a new duty, to examine compatibility of legislation, which Parliament has provided for in the Human Rights Act, and in particular in cases of suspect grounds discrimination, in cases of interference with freedom of expression, that is an onerous duty to examine the cogency of any justification advanced. Now, you may take the view ultimately that it's not for the court to say how the line ought to be drawn, but you can give expression to that concern at the stage of remedy by saying this is a matter for a declaration of incompatibility rather than a
Well, that's a different issue, isn't it? That's at the next stage. We're still dealing really with justification.
Yes, absolutely.
You realistically there, if you don't mind my saying so, recognise that this court might very well be reluctant to start wading in and rewriting statutes. However one puts the way in which one does it, still seems to me potentially rewriting statutes, but we might very well conclude that a declaration of incompatibility was appropriate. But at the moment we're on whether manifestly without reasonable foundation is the right test or not, or whether it's a more general test of proportionality.
Yes, but what I was going to go on to say is you may have difficulty saying where the line is to be drawn, but you shouldn't have difficulty in saying that the line shouldn't be drawn here, where it is. Yeah, that's the compatibility question. Is it defensible to exclude from exemption donations to a political party with very substantial national support, with then 1 MP, 2 MPs through by-elections? You are concerned with the circumstances of this case, and my submission is the line is incompatibly drawn as far as this case is concerned. What you then do about it, by way of remedy, is the next submission. And on manifest without reasonable foundation, my submission is, along with Lord Justice Hickenbottom, is that's not the test. We are very far away from welfare benefits and large-scale measures of economic or social policy. But I accept a degree of deference to primary legislation in a relatively sensitive area is called for. But the sensitivity of the area, let's not go too far on that, the sensitivity of the area derives in large part, from the fact that this is discrimination on a sensitive ground, political opinion.
Yeah.
Where the court's duty is enhanced.
Yeah.
So that then, I think, leaves the question of Section 3 interpretation. And I think my Lord was suggesting that I realistically accepted something, or would realistically accept something. Well, I'm not going to.
I wasn't seeking to dissuade you from seeking to persuade us to wade in, Mr. Coppelhouse.
Well, I'm not persuaded, and I submit that the the Upper Tribunal went badly wrong in its application of the Section 3 Human Rights Act tests. And the main problem with the Upper Tribunal's approach, as we explained in our skeleton argument, is goes back to the aim of the legislation which it identified. And because it had identified the aim in such specific terms, encouraging the flow of private funds to political parties for the strengthening of parliamentary. I'm not going to rephrase what they said, but their aim was expressed in a way which captured the effect of Section 24, and that then led them to conclude that any reinterpretation of Section 24 would go against the grain, would contradict a fundamental feature of the legislation. Whereas if they had started with what we say is the appropriate underlying social objective of channeling funds or encouraging the flow of private funds to political parties, they would not have disabled themselves from understanding what goes with the grain of that and what doesn't. Now the principles are well established, and I don't think that there's any real dispute between the parties. But I'm just going to show them to you in bundle 1 at tab 26 in the Vodafone 2 case. This was a EU law tax case, whereas you see from the head note between letter E and F, the European Court of Justice had decided in an earlier case that the UK's controlled foreign companies provisions introduced a restriction on freedom of establishment, contrary to Article 43 of the EC Treaty, which could be justified only if the objective of the were to prevent wholly artificial arrangements designed to escape the tax normally payable. And accordingly, if the measure applied where it was proven on the basis of objective factors that despite the existence of tax motives, the control company was actually established in the host state and carried on genuine economic activities, there it was contrary to Article 43. And what Vodafone submitted was that the UK legislation was therefore contrary to EU law and unenforceable, and the commissioners responded by saying that it wasn't unenforceable, it simply had to be reinterpreted. See letter G. The commissioners held that the motive test in section 7843 could be interpreted in such a way that there would be no apportionment even where there was an intention to obtain a tax advantage, and so forth. And what the point was being made. See the held at letter B on the following page is that a conforming interpretation could be achieved not by adapting the motive test, but by introducing an additional exception relating to companies which in the relevant accounting period were established in another member state of the EEA, carried on genuine activities there. So what the Court of Appeal did under the guise of interpretation consistently with EU law was to read in, to add a new exception to the relevant legislation to avoid the incompatibility which the Court of Justice had found. And the principles which led it to do that are on 724. Which were, they've been summarised by one council and in terms which the other council, from which the other council did not dissent. And the court will see what stated between D and F, and then at paragraph 38, the indented text there as well. These now form the accepted principles.
Yes. I mean, perhaps the first blush slightly surprising aspect of all this is the way in which English law has decided to follow the Human Rights Act approach in section 3 when dealing with conforming construction under EU law, which is of course an entirely different context. But anyway, there it is. I think it's
Different context, but
ever since IDT card services, which is where that decisive step was taken.
yes, but the same, I suppose, the same language it interprets so far as possible. In accordance with one particular points that we would emphasise is that letter D between E and F on 301, this is not an exercise in semantics or in linguistics. It permits departure from the strict and literal application of the words which the legislature has elected to use. And letter F, the precise form of words to be implied, does not matter.
Yep.
Which, for a common lawyer, may seem a surprising approach, but there we are. And the text at letter H is the test that we all accept. The new meaning should go with the grain of the legislation, be compatible with the underlying thrust of the legislation being construed.
Yeah.
The only additional point I would make is that paragraph 39, Sir Andrew Norris says, without in any way suggesting that it's incumbent on he who contends for a conforming interpretation to spell out exactly what it is, well, that would be to gainsay the proposition in 37F on the precise form of words doesn't matter. It undoubtedly assists in the consideration of whether or not it is a permissible interpretation to see on paper how it is suggested that it would be affected, whether by interpretation, deletion, rewording, or otherwise. Now, what I would emphasise in terms of the exercise which this court would have to embark upon in this case is that if you find that there is an incompatibility, that my client should not have been subject to tax on the basis on which section 24 apparently required, then your concern will be to find, if possible, an interpretation which avoids the incompatibility in his case. Avoid so far as possible the incompatibility in his case. I'm not asking you, and you don't have to, look for a new interpretation which will apply across the board in every case. It's a matter for the government and Parliament to consider in the light of any incompatibility you find, whether the terms of whether and how the legislation ought to be amended for everybody else in the future. My concern is with my client, and your concern is with my client and his convention rights. So, for example, if you were to reject almost everything, or almost all my complaints about section 24, but you saw force in the point that a party with MPs as a result of by-elections should not be ruled out, then you could adopt an interpretation of Section 24, which accommodated a party with MPs elected through by-elections. Now that may not be where the government would want to end up forever in the future, but that's a matter for further consideration by Parliament in due course. Your concern is with this case and these facts. So we have given some suggested reinterpretations in paragraph 63 of our skeleton argument. Notwithstanding that we don't have to. First is applying the exemption to parties who had succeeded at the last general or other election. So not just the House of Commons, but could also be the European Parliament or devolved legislature. And that, we say, would update the scope of the exemption to reflect the key constitutional developments since 1975. The second suggestion is very much tailored to the facts of the present case. It takes in MPs being elected not just at previous general election, but the succeeding general election as well. The Upper Tribunal said, well, we can't do that because that would be to make your tax liability depend on events in the future. To which my learned junior said, well, that's what potentially exempt transfers do in any event under this scheme. You don't know what your liability is until you see whether you live for 7 years or not. And thirdly is the by-elections point. But any of these proposals would be a relatively small adjustment to the legislation in comparison with what was done in Vodafone 2, which was to add a whole new exception to the scheme. And it didn't matter how it was worded. The objective is, the imperative is to bring about compatibility if at all possible. And then if the court doesn't feel that there is a possible reinterpretation, then it's we submit a case for a declaration of incompatibility. And unless I can assist further, those are my submissions.
I think nothing at this point. Thank you very much.
Thank you very much indeed, Mr. Coppell. Sir James.
My lady, just by way of introduction, we submit that the legislation before the court and its background are relatively simple. Parliament evidently wanted to encourage the funding of political parties at Westminster through private donations through the tax system. For that purpose, it had to define the concept of qualifying political party. It had to draw lines, therefore, for that political purpose. And it could have done so in a whole variety of different ways. It in fact did so in the terms that you see in section 24.2 of the IHTA, evidently taking the view on the face of the legislation that this particular type of encouragement to fund or to contribute to the funding of political parties should apply and should only apply to those parties that won at the last general election and two had either 2 MPs or 1 MP with not less than 150,000 votes. The position is that Section 24 has been in primary legislation for over 45 years in precisely the same form. But there have, as you've seen from the snippet of the papers you've been taken to, including the Neil Review and so on, there have been repeated reviews of the general topic of funding of political parties, and indeed of this provision itself. You were taken to the passage where Lord Neil considered this particular provision, and Parliament has decided that no change needs to be or should be made. It's not therefore as though the issue has lain unconsidered on a dusty shelf. It's been the subject of hot political debate along with its broader ramifications for a relatively frequent interval since, and Parliament has decided no change. Against that backdrop, the principal issues in this appeal are whether that definition in 24.2, or importantly that restriction in 24.2, treats the appellant less favourably on the grounds of a status protected by Article 14, and if so, whether in a context involving tax exemption and the broader tax system, and with all of the sensitivities, social and political, of the issues involved, and with primary legislation with all the breadth of respect or margin that those matters imply in combination, the definition was beyond the range of permissible legislative responses. And we submit that the answer to both of those questions is no. I start with discrimination and status, and I am very, very well aware that all members of this court will have had to grapple with the slippery taxonomy, if I can put it that way, that is Article 14 of the ECHR. They are difficult concepts. They are inevitably influenced by the particular facts of particular cases. And there is perhaps real wisdom in Lady Justice Rose's comment in the most recent case of TP that you were taking to at the very back end of Bundle 3, which is that when you're considering these concepts, all the facts play in. They self-evidently do. And so the starting point, we respectfully submit, is to see whether there is, as it were, at least a little bit of firm ground before you get to the swamp. And so far as that is concerned, a number of points can be made, I hope without too much controversy. Firstly, the criterion that Parliament has chosen to use for the exemption is cast in terms by reference to the objective or neutral standard of minimum success at the last general election. It is not cast by reference to the nature of the political party or the views that that political party espouses, or the beliefs or the views of individuals who might support them. It applies, according to its terms, therefore, neutrally across the range of political views. Doesn't matter whether you're a communist or a Green Party member or a UKIP member, Tory, Lib Dem, Labour, matters not. Secondly, the result of that is that by definition, if the party supported by an individual does not achieve that success, the exemption is not available. And that is because the party of whatever hue has not achieved success. It applies, as I've said, to UKIP, to the Greens, to the Communists, to whoever. It is not, thirdly, therefore, a provision that on its face discriminates or even differentiates on any basis other than success. It is therefore fundamentally unlike either of the sorts of provision that one normally comes across in discrimination cases. I mean, normally the legislative provisions one is considering are provisions which say either, on their face, let's say, take benefits as the paradigm example. A benefit is to be paid to men and not women. Absolutely clear. Direct discrimination, protected characteristic, on the face of it, there it is. Or it says, we take away housing benefit. On its face, entirely neutral, simply taking away housing benefit or reducing it or whatever you're doing with it. But the consequence of that, of the facially neutral provision, has a disproportionate impact on, say, women, because it impacts more on single-parent families, and a significantly higher proportion of single-parent families are parented by women. But those are the two classic examples, and this provision doesn't quite fit within either of those molds. So it requires a bit of trying to impose the slippery taxonomy onto a slightly unusual provision, we respectfully submit, which is why I've started where I've started. But it isn't, as I say, like either of those sorts of provision, and does therefore require a particular thought in this particular context as to how the traditional mechanisms of discrimination map on, if at all. And to do that, we respectfully submit, it is critical to understand how the provision actually works and what it is actually doing, which is to differentiate on the basis of success, not of political view or opinion. And so if, and to the extent that it does, as it plainly does, if its effect tends towards excluding from the benefit of the exemption smaller or upcoming parties, or those who don't satisfy the criteria and are not participating in Westminster in the way defined by 24(2), again, the consequence of that, or the reason for that, is not because it's distinguishing between the views of various political parties, or it considers that smaller parties have less interesting political views. It is simply because they haven't reached the minimum level of success. So that is the fundamental point to bear in mind as one considers the different categories of discrimination in issue. So turning first to direct discrimination, does it directly discriminate against the appellant on the grounds of his political opinion? And the basic answer that we give to that at the discrimination stage is that lines are plainly drawn by section 24(2), so there are plainly differences of treatment, but they are drawn on the basis of success at election, at the last general election, and not on the grounds of political opinion. In other words, the status or protected characteristic of political opinion is not the reason for the treatment in the exemption. The appellant says that the discrimination was direct on the grounds of political opinion because he was liable to IHT because he donated to UKIP, whereas if he'd held a different political opinion, he would not have been. The difficulty with that submission is that for the application of legislation to result in direct discrimination, the legislation must treat people differently because of the protected characteristic. I don't invite you to turn these references up. If at any stage I give you a reference and tell you what it says and you want to go to it, I'm very happy to. But that point is made very crisply by Baroness Hale in ESOP and the Home Office, Authorities Bundle 2, tab 40, at paragraph 17, where she said the characteristic has to be the reason for the treatment. And you get the same basic idea from Preddy and Bull, which you were taken to this morning, Authorities Bundle 2, tab 32, at paragraphs 19 to 21. Remember the paragraph citing from James and Eastley and the two advocates general to the CJU, those paragraphs. But what they indicate is that there must be exact correspondence between those who suffer the disadvantage and those who have that characteristic. The appellant's protected characteristic here was supporting UKIP or having a political opinion in favour of UKIP. And he must therefore show, applying that Supreme Court authority, that the legislation treated him differently because he supported UKIP. And we respectfully submit that the legislation did not do that for the reasons correctly given by the Upper Tribunal at paragraphs 72 to 74. In essence, the legislation does draw lines, but they are on the basis of success, irrespective of political nature of party or opinions its supporters hold. It applies to UKIP, it applies to the Greens. They may be in after one general election and out after the next, in and out of the exemption, I mean. Section 24 does not differentiate between people on the basis of their political opinion. It doesn't say that people who donate to the Green Party get an exemption, whereas those who donate to UKIP do not. It differentiates on the basis that the exemption only applies dependent on minimum degree of Westminster electoral success. It is entirely irrelevant or extraneous what political complexion or menu the party in question advocates. Put another way, you can't know from the face of the legislation to which party donations it will apply and which it will not. It is facially neutral in that sense. And we submit that the Upper Tribunal did correctly rely upon the fact that UKIP met the Section 24 conditions after 2015 as an illustration that the legislation does not directly discriminate on the basis of political opinion. What that fact demonstrates is that UKIP supporters were not prevented from qualifying. And the significance of that point, the comparison between Greens and UKIP being in one day and out the next, as it were, by reference to the general elections, is simply to illustrate that the criterion in question has nothing whatever to do with political opinions and everything to do with minimum quantity of electoral success. So we entirely agree with the thought in the exchanges this morning that says, I can't remember which member of the court put it, but we entirely agree with the thought that says it would be no answer to a direct discrimination claim to turn around and say, well, Mr. James is going to be 65 at some point in his life, assuming mercifully he lives that long. Of course that's right. That isn't, however, the use to which that example was being put. UKIP and Greens drifting in and out of the exemption, as it were, depending upon the result of the election, demonstrates that the criterion is success and not political opinion. And likewise, there is nothing and no advancing of the argument by Mr. Coppell's device of saying, well, freeze it in time and then put the relevant parties who are covered, because they did well enough in the general election, in a schedule to the act, as though, da-dum, with a drum roll, that told you that this was directly discriminatory on the face of the legislation. With the greatest respect to him, that example goes nowhere. all it does is to illustrate the operation of the substantive provision that you are considering, namely 24(2). And it's a matter of supreme indifference whether or not the result of the operation of that set of substantive conditions leads to something in an annex to the primary legislation which is then periodically altered after each general election, or you just work it out as the tax inspector as you go along, because the party in question either did or didn't achieve that result in the general election.
Because either way, the conditional criterion is success of the election.
Exactly so.
So the phrasing of the statute can't make a difference.
My lord, exactly so. And I'm afraid we're going to get very bored of this line of argument because it's the answer we respectfully submit to almost all of it.
It illustrates the, I mean, if you're right, which of course I'm not for a moment expressing a view on, but how one wrong turn taken at a very early stage of the analysis can have knock-on effects really throughout.
My lord, yes, and throughout is right. And that was why I made the apology, because I'm going to keep circling back to this.
Well, in a similar way, of course, Mr. Coppell had to keep circling back to his identification.
That's true.
But I mean, it's not a criticism, it's just a reflection of the way the issues tend to be woven into each other in this type of a case.
It is, and that was really the reason why I started with what I described as the firm ground amidst the swamp, or before you get to the swamp, because in fairness, if one reads the very many judgments that Baroness Hale has delivered on the subject of discrimination, that, and as I know full well to my cost,
You're allowed to say that now.
in a number of these cases, that's the technique. She starts with the firm ground. This is what this provision actually does. This is who it affects. This is the way it's done. And now, what does that tell you? And that's why we start here. And there's no possible way of approaching these provisions and reaching the conclusion that they differentiate between people on the grounds of their political opinion. They don't. They do it on the grounds of success, and very deliberately. So that's the first way in which the appellant puts the case.
But there must have been, just following up on that point, as it were, I mean, there must have been points in time over since 1975 when there have been other parties who have potentially not succeeded or have succeeded at general elections. I can't remember how many MPs now the SDP got in 1983 and then in 1987.
Yes.
But they certainly went in and out on, and probably got to the point where there was only one or possibly two. But
the line is porous, but the way of getting through the porous line is success, not turning up and saying I'm a communist.
Yeah.
The alternative way in which my learned friend puts the direct discrimination case is to say that, well, even if he's not right as a matter of how you approach the legislation, there's an indissociable link between the support for UKIP and the donations to UKIP. But again, that suffers from the same difficulty. If you're approaching indissociability in that sense, you need to approach it on a correct basis. And at the time of the donations, supporting UKIP coincided with UKIP not meeting the criterion. The two, however, are plainly not indissociable because UKIP did meet the criterion in 2015. And just because UKIP supporters cannot meet the criterion at any particular point in time doesn't render the criterion indissociable from political opinion. Indissociability requires that the express criterion used is in effect a proxy for the protected characteristic. That was the position in James and Eastleigh. Age of retirement being different directly corresponded to men and women. And for further references on the same point, making exactly the point about it being the express criteria, which must be the proxy for the protected characteristic, can I give you two other references? Preddy at paragraph 21 you looked at already, and Lee and Asher's baking, the one about baking the cake and putting things that were contrary to the belief on the top of the cake. Again, Supreme Court, Authorities Bundle 3, tab 50, 1841, at paragraph 25. But supporting a party that has not achieved success is not a proxy for being a UKIP supporter, as the drifting in and out plainly indicates. So that's what we say about ground 1 and direct discrimination. The question then is whether it indirectly discriminated against the appellant on the grounds of his political opinion, which again is the way it's put at that stage. And the test is therefore whether, at this stage, whether there's a disproportionately prejudicial effect on a group. But the same point applies as to the test. A number of citations in relation to that, and they all go to the same point, which is that to qualify as discrimination at all, there must be systematic differences on the ground of a protected characteristic. And that point emerges very clearly from the passage from Lord Mance's judgment in Stott, cited in the Upper Tribunal judgment at paragraph 86. It emerges also very clearly from the judgment of the Master of the Rolls in Delve about the pension ages for women from the 50s and 60s. That's in Authorities Bundle 3, tab 55, and the relevant paragraphs for this purpose in the judgment of Lord Sir Terence Etherton, Master of the Rolls, 76 and 81, in which he emphasised the requirement for the prejudicial impact to be, as he put it, quote, as a result of the protected ground. And you get precisely the same point in the Essop case, tab 40, at Baroness Hale, in relation to indirect discrimination at paragraph 25.
Could you just repeat the reference for Essop?
Essop is tab 40, para 2020. So again, you need that correlation, you need that requirement, this time between the prejudicial impact and the protected ground. And it is in essence here, therefore, the same answer, which is that it is evident that the result of criterion of success, which is what the legislation does, is that those who are successful get the advantage and those who are not successful don't. That isn't, of course, the usual indirect discrimination context where you have a completely facially neutral provision which then, on the facts, materially impacts in a different way on different groupings. But if it's indirect discrimination or nothing, you've still got to draw that degree of connection between the two. And the appellant is not treated any differently by the lines drawn from the way he would be treated if he supported any other party, not represented at Westminster. Political opinion, as the Upper Tribunal correctly concluded at paragraph 85, has nothing whatever to do with it. One can put the same point a slightly different way, closer to the usual indirect discrimination language and analysis. There is nothing in the provision or here that singles out or particularly impacts UKIP and its supporters because of their political opinions. which is the way, or closer to the way in which the Upper Tribunal put it at paragraph 87. And that is the real and central answer to the indirect discrimination way of putting things. You've seen we referred in our skeleton, and the Upper Tribunal referred pretty much by way of a passing sentence or two to the evidential position and what needed to be demonstrated. And with respect, we see the force of some of the points that were being made this morning about the difficulties of, as a matter of evidence, going too far down that line, because it is, at least on one view, strongly arguable that you can create prejudice or impact or detrimental impact from the way in which the legislation works, whether you do it by saying very simply he has to pay tax, others don't, or you do it by saying, as I think my Lord was tempted to do, well, look at the nil band, you're eating into it for the future, so that gives you less to play with tomorrow, or you do it in any other way of approaching the analysis. The hit, as it were, the prejudice is to some extent self-evident from the way the thing is set up. The question is what causes it. And that's a question which is just as relevant to the indirect discrimination analysis as it is to the direct discrimination analysis. So the third way of putting it is discrimination on the grounds of being a supporter of a party which did not have any MPs following the 2010 election, alternatively discrimination against UKIP on the grounds that it didn't have any MPs following the 2010 election. I'm going to park, if I may, the latter way of putting it, the associative discrimination point, on the basis that I want to think some more about what precise position we take in relation to that overnight. But I put down the marker even at this stage that there appears to have been no sign of that way of putting the argument in the FTT or in the Upper Tribunal or in my learned friend skeleton for the purpose of this court. So there is a problem with having to react on the hoof to that by reference to the passage you took you to today, Guberina and Croatia. We'll need to have a look at that case overnight and think about whether we take a procedural objection to this way of putting it. But I can deal with the first way of putting it because that has been, I think, maintained. If my learned friend is abandoning that first way of putting it, then I can park this and go straight to justification. I'm not inviting him to jump to his feet and confirm if it's easier not to, but let me assume for the sake of argument and now that is still being maintained. Mm-hmm. So that's him being a supporter of a party which doesn't have any MPs following the 2010 election. And we make a number of points about that way of trying to put the discrimination analysis, which principally focuses on status. The first point is that there is a very strong degree, we submit, of artificiality about all of that. There was no evidence at all that the appellant supported or supports parties who did not have an MP, i.e. that he was positively interested in the plurality of democracy and therefore supported parties without MPs. Rather, his case was simply that the party he supported happened not to have an MP at the time of the donations, and he didn't like the fact that the legislation shut him out on that basis. So a strong degree of artificiality about trying to put the discrimination point on this unreal factual basis. Secondly, we do submit that the status he asserts is defined at a particular point in time to serve these particular donations. But we say that, so far as he is concerned, it simply reflects the criterion set by Parliament. And for that reason did not comply, as the Upper Tribunal correctly found at 124, with the independent existence condition. As the Upper Tribunal summarised that independent existence condition at 102, that deals with a situation in which, as they put it, a personal characteristic cannot be defined by the differential treatment of which a person complains. And the reason for that in principle was the one pointed out by Baroness Hale in Stott, Authorities 2, tab 47 at 209, because if that was the position, every difference is a status. And you'd, apart from that point, you would do away with Article 14 and its list. The list may be difficult to comprehend and may have uncertain boundaries, but if you allow it to be defined simply by reference to the provision which differentiates, you do away with the concept of status altogether. And that outer limit was something which has been maintained in the case law throughout, including in Stott. And the position is, as we understand it, the appellant doesn't dispute that there is such a condition. You can't have it in that way. He accepts that the Upper Tribunal described the case law as it stands accurately in 104, pretty much through to the end of 121 in their judgment. So 104 to 121. And we respectfully submit, rightly so, there's a pretty crisp definition of this requirement in the Supreme Court in the judgment of Lord Hughes in Doherty, again about prisoners, in Doherty, which is Authorities Bundle 2, tab 38 at paragraph 63, making the point, to use his language this time, that the alleged status cannot be defined entirely by the alleged discrimination. That was the way he put the point in that short, single, helpful paragraph. But my learned friend's submission is not so much that there isn't such a requirement for all the controversy that has existed in Strasbourg and for all Lady Black and Stott doubting and querying whether it does or it doesn't exist as a result of Stott and the United Kingdom and all of that. That's a debate to rage for another day.
That is the point that's raised. Is that one of the points that's raised in the latest, in the case that's before the Supreme Court or not?
In C, I think it is.
Yes.
I think it is. I mean, there was, and it was slightly went off on a slightly strange basis, C, because different arguments were then run up there. But I think that is one of the grounds that needs to be considered. In fact, I'm pretty sure it is, because a significant part of Lord Justice Leggett's judgment, my lady will recall, was devoted to that issue, which ultimately resolved itself on the basis, if I recall it correctly, and in very broad summary, and doing no justice whatever to the intensity of the analysis in that judgment. But it was resolved in the end on the basis that households were perfectly understandable and pre-existing things that sat alongside the criterion in the legislation, which was all to do with children. So I think we will get some further guidance on how to approach all of that, and we'll probably get some guidance on margin, and we'll probably get some guidance on UNCRC. So we will get all of that. And there are some cases, I should say, because I'm very well aware of my Lord Justice Henderson's views about the nature of status and the Strasbourg jurisprudence, which is that it's jolly difficult to find cases in which Strasbourg has said, no, that won't do as a status. You've got
yes, well, I don't want to push that too far, indeed. I mean, I only said virtually.
Yes, I mean, there certainly have been some.
Point. Yes.
I mean, one can perfectly happily accept, without disrespect to anyone, that the lines of distinction that have been drawn do not admit of a terribly easy, coherent, principled basis in terms of the distinctions that are and aren't drawn. But certainly in relation to some prisoners, I know that that's very directly an issue in a case which is going through the courts at the moment, I think, about those changes that followed Fishmongers Hall, extending the period before you were allowed to get out at half time. Now it's 2/3, all of that.
2/3,
And there was a judgment from the Divisional Court, which I think is going up for Court of Appeal in relation to that, but they there held no status, but on the grounds of those prisoner cases considered by the Supreme Court in Stott Minter and all that line of cases. So there are some, but it can't be defined entirely. Mercifully, doesn't seem to be much dispute about the principle that it can't be defined entirely. The only question is whether it is in this case. And my respectful submission is that on that issue, the Upper Tribunal's analysis, particularly at 123 to 126, was correct on the basis that what the alleged status does is simply to use the criterion that the legislation uses to decide who gets the tax exemption. And the legislation says you don't get an exemption if the party you donate to does not have an MP, short form it. And the appellant is saying I was discriminated against because the party I donate to does not have an MP. He's simply taken the dividing line used by Parliament and placed himself on one side of it. I mean, supporting a party that does not have an MP is only relevant, it might be thought, because it is used in 24. Being a supporter of a party without an MP doesn't have any relevance or consequence at all outside of section 24.
I mean, would one rather perhaps crude way of testing it be to say, would anybody have dreamt up that status if it weren't for the terms of the legislation we're dealing with? Answer no.
Answer no. But there is direct correspondence. I mean, you get into slightly strange, potentially slightly strange positions if you move it forward on the basis that if you can find some entirely kind of adventitious thing that the status does or doesn't do, whether it's a matter of domestic law or as a matter of parliamentary practice, you can then turn around, casting my eye forward to the UKIP argument and say, well, there we are, there's something else that flows from that, only having one MP or not having an MP. Ergo, it's all okay, this is a status. That seems also a slightly strange and adventitious way of doing things. But at least as far as Mr. Banks is concerned, we don't have to grapple with that because there is none. And he has therefore had to invent it. I did want very briefly to go to the TP case because it is the latest word and because the judgments are of some interest. It's behind tab 67, bundle 3, if you would.
You've now got the complete judgment.
No, you're still in.
No, I haven't.
Have you not? Normally I'd be able to turn around to my junior and say, give me yours immediately.
No,
It's
no.
electronic as well.
Don't worry, I mean, I can find
Can I make some submissions?
Of course, make the submissions and I'll find myself a complete copy.
For those who have it, I better start with the majority. 107. Which my learned friend took you to this morning. Interesting though those submissions were, in our view, they have no relevance to the present case. This is because the ground on which TP and AR were treated differently from others in an analogous situation does indeed exist independently of the difference in treatment about which they complain. When a person moves across a local authority boundary, and then this metaphysical or philosophical thought, that is a physical fact which exists in the real world. But then perhaps in terms of the distinction that is actually being drawn by what on its face might be quite a difficult concept or idea to understand here, the final sentence, which gives colour to the previous one, it does not arise from the terms of the legislation under challenge. So you've got the majority drawing that distinction, and the emphasis therefore is really on whether or not it simply arises. It's simply a distinction which exists within the world of the legislative differentiation that is drawn. The other thing potentially to bear in mind with 107, and indeed the entire side-blocked analysis between 103 and 107, is that you do in the majority judgment, I respectfully submit, need to read it with what has gone before, including in particular the recognition in 92 and 93, whereas 92 and 93 on 2636, if you just track back. Would you just have a read of those two paragraphs, because it very much gives the factual flavour to the moving across the local authority boundary. And I have in mind in particular the passages in 93, which indicate that very often the cliff edge which is faced by the movers as it were, will be brought on by their own disability in the first place. So you've got disability inextricably intertwined with the move, is the point. You see that in the penultimate line of 93 if you have that. So that gives flavour to the physical fact and the move of location, which otherwise might be thought to be a difficult concept in this sphere. But I suspect that once you read it in context and it's got that disability flavour to it, the distinction or the differences between the analysis of the majority on this part of the case and the analysis of Lady Justice Rose shrink almost to vanishing point. And I suspect it may be enough for my purpose to refer you to two passages. The first of them is what might be thought to be, if one was viewing her judgment in isolation, the ratio or principle that Lady Justice Rose identifies, and that you find by the letter G in paragraph 209. And in particular, the line, 2 lines down from G, beginning, the guidance from the court in Clift is. My Lord doesn't have that bit, I can easily read it. Is my Lord Justice Henderson?
I don't, I'm afraid, no.
No. She there says, I'll give it some flavour, the guidance from the court in Clift is, therefore, that when determining whether a distinction which only has relevance because it is adopted as the criterion for conferring a benefit or imposing a burden, thereby creates an other status, inverted commas, one must take into account all the circumstances, including whether if it does not confer such status, it will run counter to the very purpose of the protection that the Convention article is intended to confer. I mean, that to some extent is both the point that I made earlier on, slippery taxonomy, take into account all of the facts, jolly difficult to jump from one set of facts to another, and on the other hand, also gives real force to the point my Lord Justice Henderson was putting to me, which is if this status didn't exist, someone would have to invent it. Is it really something that goes to the sort of thing you would expect? Or is it just a construct from the legislative differentiation? So 209 at the end is quite important. And then critically, in terms of her analysis, which is why I took you to the flavour that was given to 107 by 92 and 93 in the majority judgment. And I won't read this because it's a long paragraph, but it's the whole of paragraph 211, if you would, in Lady Justice Rose. Can are we allowed to hand a single pager? If you'll forgive the red underlining, my Lord, and promise to give it back at the end of the day.
Thank you, I will.
it'll make sense.
I'm grateful.
It doesn't make much sense without.
Shall we just read that to ourselves?
Would you do that?
Thank you.
And that'll be the final act of the day.
Presumably you don't have it by heart, so you just
engraven. So as it were, the much fuller and rounder analysis, taking into account all of the elements that were in play, including the strong disability element, is the real point there. Well, it might be convenient for me just to give you the third point before coming to the UKIP thing tomorrow, and I'll think about that some more overnight. But the third point we wanted to make in relation to this aspect was that the alleged status is not in truth in any way a characteristic of the appellant. It depends not on personal characteristic remotely akin to anything in the categories in Article 14. It depends on the happenstance of another body, the political party, not doing well or well enough in the previous general election, or doing well in the previous general election. There has been a slightly strange and intense debate happening evidently behind the scenes in Strasbourg about whether or not personal characteristic was truly a proper description or moniker of the various concepts that are described in Article 14. And that, as you will recall, was very much the theme of Lord Walker's concentric circles analysis in RJM. And it's now become, as they pointed out in Stott, they prefer the language of identifiable characteristic. And obviously that's of some conceptual difficulty because it might be thought to be entirely question begging, because every distinction that is drawn has identifiable characteristics on one side or another. But at least you need a characteristic of some kind of the appellant, whether you call it personal or identifiable or something else. So in Paulick, the case that is normally cited and they considered in Stott about the father had the personal characteristic of being a person whose paternity had been judicially over the facts of that case. And in Matheson, again, the child had the personal characteristic of having been in hospital for 84 days. Not much you could do about that, poor child. But in this case, the personal element is which party the appellant supports. But whether he had status is determined, as I've said, on numerous occasions now, not by the views of the party or the views that he espouses, the individual espouses, but simply by reference to the success of that party. Final point to note in relation to this is that my learned friend, at least in writing, criticised the Upper Tribunal for taking into account that this alleged status would be on the outer fringes of Lord Walker's concentric circles in RJM. RJM is in Authorities Bundle 1, tab 25, and the relevant paragraph is paragraph 5. One can see from the Upper Tribunal's judgment at 126 that they placed some but very little weight on this. It's also possibly of some relevance was the introduction to paragraph 126 of the Upper Tribunal judgment. But we do respectfully submit that Lord Walker's analysis remains important. I'll come back to it tomorrow, but it remains important not least, well, it remains important for the purpose of this point because it identifies those things that genuinely can be or should be regarded as personal or identifiable characteristics. But it's also important when one comes to the analysis of justification for obvious reasons. My learned friend made a big point about suspect ground, and my submission tomorrow is going to be that you need precision in that analysis. You don't just turn up and say this has got something to do, however remotely, with political opinion. You need precision to see precisely what is being done to facilitate or create detriment for the particular thing that you're considering. So the concentric circles are relevant for that also. My lords, my lady, that takes me to the final point, which is the associative discrimination point about UKIP. And I'll come, if I may, to that tomorrow morning first thing. I don't expect to be long with it. And then we're into justification. So we're doing good on time, I hope.
Looks that way. Jolly good. Thank you very much. We'll see you at 10:30.
All rise.